Morning, everyone. No, carry on, Dr. Glasgow, to that equipment set up. Good. Okay. Morning, everyone. Just before we start, can I just raise one point with Miss Peaty? Miss Peaty, we had a letter, in fact, it was from you overnight, which said this: we write further to the hearing of today. At the end of the hearing, the Commissioner stated that the Premier had accepted that the revocation of the Climate Change Trust Fund Board was, quotes, illegal, end quotes. The Premier was surprised to hear his evidence so described, as he does not consider that it is an accurate summary of what he said. He is very troubled by the Commissioner's statement because it may be that the Commissioner misunderstood his evidence on this point. We raise this at the earliest opportunity so that there can be no mistake that the Premier does not accept this view. Now, Ms Peaty, we heard the Premier's evidence yesterday as to the Attorney General's advice in 2019 and how that advice was understood. So we have that evidence. In respect of, and I will have to make of that evidence what I will. But in respect to this concern of the Premier, as illegal is put into inverted commas, I'm not quite sure whether that's his concern, because the term used otherwise yesterday, and indeed the final direction, which we were discussing when I used the term illegal, was unlawful. And I certainly did not mean by illegal anything more or less than unlawful. So it may be that simple point. But if the concern is that whatever the Attorney General's advice was in 2019, the revocation of the membership of the Climate Change Trust Fund Board was legal, then that's obviously something that I'd allow the attorney to put in submissions on, as I have allowed her to do in respect of the BVI Ports Authority Board. So what's the position? Is the position the latter? Does the attorney want to put in legal submissions in relation to the revocation, the lawfulness of the revocation of the Climate Change Trust Fund Board?
You'll appreciate that, having sat late last night and only just come in this morning, we haven't discussed this in great length with the Premier, and I think he'll be considering the position today. I would be grateful if we can expand the submissions onto the two limbs, so it's the Climate Change Trust Fund and the Ports Authority.
No problem.
If so advised, if you're content with that.
I'm completely content with that, and I think that will simply mean amending the direction from yesterday, literally to add after the words BVI Ports Authority Board, quotes, and the Climate Change Trust Fund Board, end quotes. No problem with that at all. As the direction is framed in the terms of whether that was lawful, if the attorney, upon reflection, considers that it was indeed unlawful, then the submission can simply say that. It's only if she considers that it was lawful that she needs to give reasons. Just one further point. I'll check with Mr. Rawat that he has nothing to add to this. Well, let me go back. Both in terms of submissions and indeed in terms of notes, which include submissions and evidence in one document, increasingly these documents do not have any name on them. They must have a name on them. Evidence, I need to know whose evidence it is and who can speak to the evidence. Legal submissions, I need to know whose legal submissions they are in terms of individual advocates. So in respect of this note, which is legal submissions, so it will have some advocate or advocates' names on the bottom. That's fine. as I stressed yesterday, no evidence. As I stressed yesterday, no more than 5 pages. I stress that again because despite making directions limiting the length of documents, sometimes the IRU have put in very long documents together with sometimes hundreds of pages of annexes. That's not what I want in this instance. But also, because I think this point's very important, I would like confirmation in respect of this note that the attorney has seen the note, considered it, and confirms that that is her view. Yes.
Yes, sir. And we have been taking on board the feedback. So I think we put in 2 notes this week that do have the names of the person submitting them on. We are conscious that you don't want lots of documents. It may be that we would refer to transcripts or other documents in the record, obviously within submissions. I hope that that would be appropriate, and maybe we don't append them.
Well, that's appropriate as long as they go to the 2 matters that I've asked for submissions on, Miss Peaty, certainly. Mr. Howard, anything else on that?
Nothing, Commissioner.
I'm just getting a notebook. It's undoubtedly my fault that I haven't got it. Okay, good. Good, yes. Good morning, Dr. Glasgow. Mr. Rowat.
Good morning, Commissioner. Just to explain before I begin my questions of Dr. Glasgow, he has, with your agreement, got his own laptop with him. That is only for the sole purpose of allowing him to be able to read his affidavit on screen,
Yes.
which is something that he finds easier to do.
Yes, certainly.
Dr. Glasgow, thank you for returning to give evidence to the Commission today. I say returning because, of course, on the last occasion, you were not in the hearing room, you were remote. But on that occasion, which I think was the 8th of July, you made an affirmation. There's no need for you to do so again. The affirmation still binds you. You'll see that I think in front of you there's a bundle of documents. You'll be familiar with those. You also have the affidavit that you prepared, and we'll look at those as we go through your evidence. Could I ask you just to remember to keep your voice up? The microphone does not amplify, and so if anything you probably could do with pulling it a bit closer to yourself as we go through. The other thing to caution, and it's a caution that applies to both myself and you, is we should both try and avoid speaking across each other. The reasons for this is that we have a remote stenographer who will want to ensure that we have an accurate record of your evidence today. If I explain that, and just in terms of background and context, when you last gave evidence, you told the Commission that you first began in public service, I think in 2003.
That's correct.
And then your current role now, which you've occupied since the 17th of February 2014, is that of Director of Projects within the Ministry of Finance.
That's correct.
Now, on the 10th of March, the Commission sent letters of request to the Cabinet Secretary and the Minister of Finance, seeking disclosure concerning the provision of security services at Elmore Stout High School. I'm going to call the high school ESHS, as you do in your affidavit. The disclosure that was provided led then to letters requesting affidavits, and those letters were addressed to Dr. the Honourable Natalia Wheatley and also to the Honourable Premier and Minister of Finance. You have provided an affidavit in response to those letters. They utilise information provided by colleagues within public service, and they are intended, and that affidavit is intended, as I understand it, to address the questions that have been raised in both letters to those 2 ministers. Is that right?
That's correct. Just before we start the questions, I'd like to thank you very much for the affidavit, Dr. Glasgow. I mean, it's clear the care and attention you've given to the affidavit. The background to this is not straightforward, and it would be, frankly, without your affidavit, to me anyway, incomprehensible. So thank you for the work that you've done on the affidavit. It's much appreciated. Thank you.
And Dr. Glasgow, can I join in the Commissioner's thanks? And I think also that thanks should extend to the colleagues that inputted to the affidavit, because as you, and we won't necessarily go into that detail, but you cross-refer to information that's been provided to you.
Correct.
And that's colleagues in 2 departments, isn't it? Or 2 ministries, forgive me. Now, if I take you to the last page of your affidavit, what's, I think, your internal page 17 and our page 29.
I'm there.
Please just confirm that that's your signature, please, Dr. Glasgow.
Oh, that was there. That is
I'm sorry, could you keep your voice up, please? Thank you.
That is correct. That is my signature.
And it's dated the 2nd of September 2021.
Correct.
Unless you say otherwise, Dr. Glasgow, I'm going to ask that that formally becomes part of the record of evidence before the Commission. It's your second affidavit. The first that you provided concerned the law and practice in relation to procurement of government contracts, and that was what we asked you to assist on when you gave evidence on the 8th of July. Now, if we start off perhaps with some, I suppose, historical context, really, if I take you to paragraph 3.1 in your affidavit at page 14. In paragraph 3.1, you note that section 59 of the Education Act, which, Commissioner, for your note, you can find at page 38 in the bundle, gives the Minister for Education a power to designate school security officers to assist a principal and teachers of any school. And at 3.3 on the same page, you note there, you say that there was a history of crime at ESHS, including vandalism and theft, with numerous break-ins, a possible case of arson, together with related concerns about poor lighting and fencing on the site. And you record there the various cabinet papers in which those concerns about security at the school have been raised, some of which refer to it by its old name, BVI High School. And one of the points you note is that the school campus is open, in that the grounds are used as a thoroughfare to get to the Lower Estate and the Longbush communities. So it has it not, for some significant period of time, presented a security challenge, particularly perhaps to the staff working at the school?
Yes.
If we turn to page 43 in the bundle, this is executive council memorandum. It's dated the 29th of June 2005, but it also gives us some useful background again as to the history of security provision at the school. You'll see at paragraph 1, it's noted that in 1998, after years of vandalism, theft, and a case of arson, what was then the Ministry of Health, Education and Welfare entered into a contract with All Island Security Services Limited to provide 24-hour security at what was then BVI High School. And that contract then continued on a rolling basis. And it was still in place in 2005, the time of this memo. Then, as we see from paragraph 3 of the memorandum, a contractual agreement was entered into with Top Priority Security Limited. And I'm going to refer to them as we go through as TPSS. And that arrangement was for a block warden security system at the school. It was an initial contract for 1 term with monthly payments of $11,500, but since then the contracts have been renewed annually. So at least between 2001 and 2005, I think the position at the school was that there were 2 contractors, one essentially providing block wardens, so internal security, and the other one, I assume, providing gate security.
That's correct.
And you noted in your affidavit that the contract, the 2001 contract with TPSS wasn't available, although I think as part of your research, you and your colleagues couldn't uncover that contract.
We could not get a hand on that contract.
If we take you back to your affidavit then at page 14 and paragraph 3.6, what you say there, Dr. Glasgow, is that on the 20th of August 2003, the then Chief Education Officer wrote to All Island, informing them of a decision that their contract would be ended in September 2003, but seeking a month-to-month arrangement until the end of the year, December 2003. And the reason that was given was that the Ministry of Education was making preparations to procure a full security service for the whole campus, for which All Island would then be invited to tender. So in terms of the sort of chronology, is that the first point in time where consideration is given to tendering?
In terms of chronology and the information that I was able to come across, that is the case. I cannot confirm that tendering was not a consideration before this time, but at least at this particular point, the decision was made to move away from the original contract, which had, as you mentioned, the month-to-month, and then also the addition of services by top priority. At this particular point, the decision, whoever that decision was made from, to stop that arrangement and enter into a tender process was made. Before, as we've mentioned, since 1988, as indicated in paragraph 1, I cannot confirm that a tender process was not put in place to actually start that arrangement. It could very well may have been so.
I see.
You would note, however, that those dates corresponds to the introduction of the Procurement Act and also the procurement regulations, which started in 2005. So the Procurement Act was in 2004 and the procurement regulation was in 2005. So this, I'm not aware of any previous procurement regulations or act or legislation before that time. So for sure in 2005, they would have been obligated to follow the regulations.
So certainly that's the date to be taken at which ministries looking to engage or issue major contracts should have had the procurement regulations in mind.
Based on the timing of the procurement legislation, yes.
Thank you. If we look at 3.7 and 3.8 of your affidavit, in July 2004, the principal of ESHH recommended that Top Priority supply the security services for the whole campus. And then on the 17th of February 2005, Top Priority wrote to the ministry as you say, this was when there were still two contractors in place. But the effect of what Top Priority was suggesting to the Ministry of Education was that it would be more cost efficient and less messy for one provider to supply the security services. And they made a proposal to provide a complete service.
Correct. They did make a proposal to do a complete service. Not sure from the records why they would have done that, but for sure they made the case to actually have one company do that work.
So you say you're not sure from the records why they would have done that. So what you didn't uncover was any evidence as to whether they were prompted to put the proposal forward or whether it was an unsolicited proposal?
No.
If we go back to page 43 in our bundle and we look at that memorandum, to summarize the decision that's being sought, the first point that was being proposed to the council was that an ad hoc public school security committee should be established to examine the issue of school security in the territory's public schools and make recommendations. Then there was to be a tender process to provide and to select security providers for relevant public schools. And the idea was that the school security company would advise on the selection of those security services for the public school system. Now, that 29th of June 2005, as you just indicated, as a date would chime with the introduction of the regulations. Now, the committee appears to have been formed because you refer to it at paragraph 3.12 of your affidavit, which is at page 15. What ultimately happened to the committee?
That's a very good question. I have absolutely no idea. And the reason I pointed at that, the committee, from what I've seen, it was constituted. I've seen information coming from advice that they have given. But as it relates to, as you've mentioned, the decision sought, which says that the school security committee be designated as the official body to advise the selection. I do not see that being outside of the Central Tenders Board process because the regulations 2005 gives provisions for the Central Tenders Board to appoint, if they choose to do so, to appoint a technical evaluation committee, which could have well included persons and the advice of the school's security committee. So I see that not necessarily as a conflict, but as, you know, if you're going to get advice about what the security should be it on a tender or even to assist with the evaluation, this should be the authority. But I would imagine that around this time, as I'm not sure of the month the regulation was posted, but in 2005, I would imagine around this time that general procurement would have been in the hand of the procurement coordinator, Ministry of Finance, etc.
I want to ask you some more about the sort of current tender process, but let's deal with some of it now. You've spoken to the Central Tenders Board. So all tenders are going to go through the Central Tender Board and they can make a recommendation to Cabinet, who will ultimately make the decision as to who gets the contract. Is that right?
That's the correct procedure.
But before, what the Central Tenders Board can do is, as you say, appoint an evaluation committee to look at the tenders.
So what happens, if I may, the publishing of a tender, the invitation is done through the Central Tenders Board. So the regulation says that the Central Tenders Board shall issue a tender, not in so little words, but they receive the tenders. So Central Tenders Board would receive the tenders. They would go through, they would open them, ensure that they are in order. Then they may select a technical evaluation committee to review the tenders on their behalf, because of course they would have more technical persons on the committee. So in retrospect, everything is still being done under the Central Tenders Board purview. So even if there's an evaluation, it's because of the Central Tenders Board selected an evaluation committee.
And that the Central Tenders Board can do that could negate the need for a public school security committee, because I mean, if we take ESHS as an example, the Central Tender Board could have an evaluation committee that brings in a procurement expert who can look at it from a value for money perspective, but also you could have on there somebody with who comes from a security dimension and could assess a tender on that basis.
Correct.
And so you would achieve through that technical subcommittee the same purpose that seems to have been behind the proposal to establish the Public Schools Security Committee.
I believe and I can't say this because I haven't read it per se, but there are certain ad hoc committees that are put together to make recommendations. And so definitely what I would have seen from this particular committee are recommendations on a review of, security, etc. at schools in general, and recommendations made. But so far as a recommendation for the selection of a person, that rests in the Central Tenders Board. And what the regulation actually says is it gives the Central Tenders Board the not authority, but the responsibility to review the tenders. And what it says, the Central Tenders Board may appoint an evaluation. So the Central Tenders Board can evaluate if they so wish to. In my time with the Ministry of Finance, I have never seen that done. But they can do so if they wish. But the practice, they have employed a particular clause that said they may do that and select an evaluation committee.
And that is the practice.
Yes, that's the practice.
If we move on to 3.10 in your affidavit, please, Dr. Glasgow, and just to keep with the chronology, we've looked at the memorandum of June 2005. What happens next is that there's a proposal on the 22nd of November 2005 received by the Ministry of Education from Vanguard Security Services to provide security services at ESHS. So that's the second proposal received in that year. And again, the circumstances in which that came to be sent into the Ministry of Education, were you able to clarify at all?
No, but of course it would be unsolicited proposal.
Why do you say that?
Because it was not a part of a tender process. And we were now put under the purview of the regulations, which would have had the Central Tenders Board issuing a tender. And they, as we read a little earlier, All Island Security, All Island was actually received a letter from the ministry noting that they wish to terminate the services to facilitate a tender process. So if a proposal was sent in, it would have been unsolicited. Whether somebody said, okay, send a proposal in, or the particular company decides to send in a proposal, which appears that way to me here at this particular time. I can't say the reason why, but it's clear it's unsolicited. It was not a part of a tender process.
But it's the best that we can do between 2003, when the letter was sent to All Islands, and the end of 2005, is say that the ministry had the intent to begin a tender process, but you haven't been able to identify any documents to show that one was commenced or initiated in any way?
Before the 2005, no.
So what we're then into is 2006, and in 2006, the Minister for Education at that time, on the 27th of March 2006, wrote in reference to the ongoing security problem at ESHS and asked the matter be expedited and that the contract be awarded to Vanguard. Now, what appeared to follow was a request or a draft request on 8th of May 2006 to the Executive Council requesting a waiver of the tender process and the use of Vanguard. Can you add any more to the circumstances in which that waiver was being proposed?
I cannot. I have not been able to see anything on the files that gives specific reasons so far that it was actually done. You have noted, quite noted in 311, that the then minister recommended to Executive Council. And so what would have transpired after that in 3.12 is that given that the procurement regulations was in place, it would have been in place for them to, it would have been right for them to request a waiver if indeed they had an unsolicited proposal, which appeared to be the case in this particular case.
Yes, at that point, that was the only option. You would have to go for a waiver of the process if you wanted to use that particular company.
Correct.
Commissioner, again, for your note, we find that request from the minister at page 70 in the bundle.
70.
Yes.
Thank you.
And Dr. Glasgow speaks in his draft affidavit, in his affidavit at 3.12, and I was just asking him about it, about the draft Executive Council paper. That starts at page 55. And goes through to 59. It is a draft, Dr. Glasgow, if you look at page 56, because we can see that it had various annotations on it. But in any event, what appears to happen is that there is input, and we see this at page 71 and 72 in the bundle, from both the Attorney General's chambers and the Financial Secretary, questioning why the tender process needed to be waived. And that's part of the process as well, is that if a ministry were making a request for a tender waiver, as is the norm, it seems, with anything going to cabinet, you would need input from those two departments.
That's correct. I think that the correct term for it now, you would have one cross-ministry consultation, and you will also have a financial implications. So that would come from the Ministry of Finance. The cross-ministry would come from the particular ministry that's involved. So this is pretty standard for what would have occurred.
In any event, what seems to have happened is that it doesn't go much further, because as you say at 3.15 in your affidavit, which is on page 16, Commissioner, on the 15th of January 2007, the principal of ESHS wrote saying that Vanguard's proposal was inadequate to meet the needs of the school, considering the size of the campus. And that seemed to have brought an end to that. So the position is, as we get to the end of 2008, is that there's been, as far as can be established, no tender process since one was intimated in 2003. and security was still being provided by two firms, Top Priority and All Islands. Is that right?
From the record, that's
If we move through then your affidavit to 6.2, please.
6.2.
Yes, page 18. What you set out there is events in 2007, which covered the tender process that began in 2007 and continued into 2008. So at 6.2, you record that in June 2007, the Permanent Secretary writes to the principal of ESHS asking her to begin the preparation of tender documents. At 6.3, you deal with a draft tender notice being provided by the procurement unit to the Ministry of Education for publication. So is that, when you say it's a draft tender, that's obviously a notice intended to be published inviting tenders, is that right?
That's correct. And it's noted as draft because it would be prepared and then forwarded to the particular ministry at that time to have it go through the appropriate channels to be published.
And Dr. Glasgow, up to this time, the services were still being provided by two contractors.
Based on the records.
Yes, one, as it were, on the gate and one internal. And in terms of amounts that they were being paid, both being paid on a monthly rolling basis?
Yes, in accordance with what we referred to before.
One was being paid $11,500 a month, and the other was being paid, I forget what.
I would have to pull it up here.
Yes, I'm sorry, it's not a sort of test.
I don't know whether it's in your affidavit, Dr. Glasgow, but page 43 may help. It's paragraphs 1 and 3, I think, that cover.
Okay, yes, this is what I was looking for.
Yeah. So one of the contracts was £11,500 a month, and the other contract was just short of $100,000 a year. Is that?
Let me just. Correct, per year.
Yes. So I'm just trying to get some feel that the precise figures don't matter, but that means it's something like $220,000, $230,000 a year for the security services at this time.
For both, yes.
Yes. Thank you very
much. So if we go back to 6.3 and page 18, please, Dr. Glasgow. So we've looked at 6.3 in the draft tender notice. There is then a tender document prepared, which, as you say, at 6.4 was to be made available from the 9th to the 20th of July 2007. There's reference to the Public School Security Committee to have insight in terms of streamlining the process of procuring security for ESHS. But then, as you explain at 6.6, there were 3 tenders received in 2007 from All Island, Top Priority, and then a third company called Samuel Security. Now, the upshot was that one bid, as you explained at 6.8, was disqualified, and that was, I suppose, for failure to comply with the requirements and that they didn't provide supporting documentation. 2 of those bids went through to the next stage, which was to be evaluated. So that's again an example of the use of an evaluation committee.
Yes.
So that seems to be, as a process, in line with what you would expect under the procurement regulations.
That's correct. That's correct.
But at that stage, and again, you explain this at 6.10, one of the tenderers was disqualified, and that was because the tender period was to make a bid for 3 years, and they had put in a bid, as you said, 6.1 for 1 year.
Yes. It was supposed to be for 2 years, sorry.
I see, sorry. Yes, you're right. I'm misreading your paragraph 6.10. And again, that just didn't meet the technical requirements. So the upshot was that the company that was left was top priority, and top priority was recommended for the contract. Now, what you said at 6.10 was that the bid evaluation took place on Wednesday, the 15th of August, 2007. The tender evaluation committee appeared to have contemplated granting more time to the bidders because of concerns as to the lack of clarity in the requests for proposals. However, given the urgency of the situation, they decided to proceed. And so, was it a situation where the evaluation committee was in difficulties because you had to have, I think, because the start of school term was imminent,
September.
You had to have security in place. Is that right?
That's correct. I would presume that was actually the case, because the evaluation is taking place on the 15th. We do not have time to go out to tender again. And in terms of the clarity in the lack of clarity, I wasn't able to put my hand on the bids, but based on other bids that we probably will talk about a little later, just in the response to the tender document, persons, and if I just give an example, someone would say, well, I need 10 persons 10 officers to properly secure the facility. Another bid would say, well, I need only 2. So clearly they can't be singing from the same page. It cannot be, in terms of interpretation, they cannot be interpreting apples and apples. If somebody's going to take 2 officers to cover the entire school, when another person will say 10. So looking through the bids and seeing inconsistencies like those, it's where, at least if it was myself doing the evaluation, I would have said, well, there has to be a lack of clarity because they don't understand exactly what's required. And so that may have been the what actually happened there. And so you can't go to tender within a couple of months. Clearly, everyone, be it the Ministry of Finance, and also, as we looked earlier, the Attorney General, wanted us to get from this month-to-month rolling and start ensuring that we were following what was passed in the regulations. So we did not have that much time. So I would presume at that time, September is upon us. School will start in September, so we do not have time. Let's proceed with the project.
Right, because it was better, rather than maintaining the month-to-month.
Yes,
it is better to at least continue with the one company that had gone through the process.
Well, not to continue with him, but to proceed with the evaluation. I wouldn't. I mean, the evaluation perhaps did not was not completed before. So based on what you just opinion on, the evaluation took place, but I can see that the evaluation committee wanted to continue the evaluation process with or without the lack of clarity, as mentioned there, even before they would have noted, or even before it was concluded that only one effective bidder would have been there because 2 were thrown out. Based on what I see in the documentation, it does not say that let's not proceed with the evaluation of the tender process because you only have one bidder. It did not say that. So I wouldn't really use the language. It may have been better to continue with the person who have been providing it. It's just for them to continue with the evaluation process through the end, no matter what those results came out to be.
So I think the two questions from that. First is that, is what you're saying is that your analysis of the documents at the time suggests to you that the committee said, yes, we only have one bidder and one bid, but we will continue with the process.
No, no, I didn't exactly say that. What I did say is the committee would have said, even though the time is short, and even though there may have been a lack of clarity in the documents, let's proceed with the evaluation process. I presume, or I could imagine that that happened. And then after that is when they saw that perhaps there was only one effective bidder. I wasn't there, but based on what I see, it suggests that.
So they looked in general at the documents, made a decision before getting into the specifics of the bids.
But what your affidavit indicates is that there was only one bidder left at the end. Was evaluated and was found to be acceptable in terms of provision.
Correct.
Yes.
But the fact that they were willing to proceed with an evaluation, knowing that there was a lack of clarity in the request for proposals, does that render the process defective?
Effective or defective? No, I would not say that. I think the impetus was, we clearly have a situation of the lack of security at the school. And we are now obligated under the regulations to ensure that we go through a tender process and have it completed. Now, even that may not have been the most clean cut, or let me use the word effective, follow through of a tender process, yielding a good result of a tender process. It just shows that a tender process needed to happen. And that particular, I can imagine the chairman of the Central Tenders Board at the time wanted to ensure that occurred. Because you would recall, we had, just before that process, the records show that the Attorney General spoke about it and said there was no tender process. And that's the legal entity of the, I'm very sure that they would have consulted the regulations. And so they've said, okay, it's not good to not have a tender process. And also you had the Finance Secretary giving an opinion on it as well, to say he's very concerned about, he or she, I'm not even sure who was it back then. But there was a very big concern that there was not a tender process. And so I believe there may have been, I don't want to say pressure, but the impetus was to ensure that this is the first tender process that we're doing to get security at the high school. Let's complete it. And that's one. And then, of course, Commissioner, we had to have this in place within a month, well, less than a month.
I mean, the choice, given that the board, the tender board, only ended up with one bidder, they really had a choice, didn't they? They could either say, well, this is what the process has resulted in, and it's acceptable. That's fair. The bidder is acceptable, and this is the process, and this is the successful bidder. Or they could have said stop and re-tender, go through the whole process again. But that would risk, well, it would certainly have meant, I think, that the bidding process, the tender process, would not have been completed by the start of the school year, which would have meant continuing with the monthly arrangement, at least for a time. Those were the choices, weren't they?
That's correct.
And they chose to say, well, this is the process, this is the successful bidder, and we'll go with this company.
That's correct.
Yes.
And there's absolutely nothing incorrect about that decision. There was an open tender and persons submitted. Some tenders did not adhere to the particular requirements of the tender process, and they were rejected from the process, and it yielded one bidder. It would have been the same if only one bidder submitted.
Exactly.
One bidder responded. It's a fair process.
Yes. No, exactly. Yes.
If we go on to 6.13, so we have the position we've reached in the chronology is that top priority are now the persons who are recommended by ultimately the Central Tenders Board for the contract. As you say, at 6.13, on 12th of November 2008, the Cabinet decides to award that contract to Top Priority Security Services, and it's for a 2-year period. And so, and Commissioner, again, we see that, and we don't need to necessarily bring it up, but the record of that is at 356 to 358. The contract was for $455,550 for a period of 2 years. But what you then record at your 615, Dr. Glasgow, is that according to the then accounts officer at ESHS, who you spoke to for the purpose of preparing your affidavit, a paper contract was not issued. And this was Mr. Pete Smith, the accounts officer. He recalled that the accounts department at ESHS was told to proceed with month-to-month payments, which continued for more than 2 years. So what does that mean in terms of completion of the tender process?
I would say the tender process was completed based on what I've seen. It was completed. In speaking with Mr. Smith, of course, he does not recall a paper contract being issued. Of course, you would have had the legal part of it. You would have had a decision made by the Cabinet based on the recommendation of the Central Tenders Board, and that happened. And so Cabinet made a decision to award a contract. Now, I have not seen a contract. According to Mr. Smith, one was never issued. I'm not exactly sure what that means, but he recalls, as mentioned there, he recalled that his particular department was told to proceed with the month-to-month payment, which continued for more than 2 years. Month-to-month payments would have been the order of the day, because even if a contract was signed, the payments would have been monthly, right? So what I'm seeing is it's being acted on the decision of Cabinet, which is appropriate. It's just we do not have evidence that something was actually signed. But I can imagine what would happen. Once a Cabinet makes a decision, the Central Tenders Board, through the procurement unit, would issue a letter to Mr. Smith and say, hey, you won the tender. If there are any documents to be provided to government, do so. I can imagine that's what occurred here. But Mr. Smith does not recall, and neither have I seen the contract.
And I think this simply records that the mechanics of payment carried on as usual.
Yeah, it carried on.
The mechanics of payment.
Yes. And once this particular type of service, what the bidder would have done is put in his tender a payment schedule. And that payment schedule would have likely be, as from seen over the time and what we've seen as the years go by, a month-to-month.
Yes, X dollars a month.
Correct.
Yes. And obviously, because it's for 2 years, it takes us through to 2010. And you say at your paragraph 7.1, there was no tender process in 2010. But Mr. Smith's recollection was that there was to be a tender, but the process was stalled. Did you find out any more about why the process was stalled?
I did not. Suffice as to this is what happened. I mean, as mentioned up earlier in the affidavit, well, all of the files at the procurement unit were lost, and I think it was also mentioned when I spoke to the permanent secretary. The current permanent secretary was who made inquiry into these before. That particular file was lost, and I mean, it's no secret the admin complex which housed that department, it was totally trashed, for lack of a better word. So I don't imagine that there was a file for him to say, okay, a tender process, whereas he started to prepare the tender documents, and somebody said to stall it, or it just never promulgated to the next stage. I don't see any documentation within the procurement unit on the records, on the electronic files. I have not seen any to suggest that a tender was actually drafted. So that's why it's written in that way.
So after 2010, the contract, the 2-year contract, just rolled over on a month-to-month basis.
Yes.
Yeah.
And it seemed to be that it wasn't until we get to 2013, and that's your paragraph 8.1, that there is a return to a tender process.
Correct.
And so would it, given what you said, 7.1, does it follow that between the end of that 2-year contract in 2010 and 2013, there was no compliance with the procurement regulations, because the contract had, there was no return to or attempt to go through the tender process again. Rather, we had defaulted back to the situation we saw before 2008, where it was people being paid on a monthly basis.
Yeah, I mean, it's, one can infer that, but I can't say that for sure, because knowing the public service, knowing persons want to ensure that they do what's correct. You know, I can hear Mr. Smith, I can hear the permanent secretary just whispering in someone else, shouldn't we be doing a tender process? And there may have been tender documents prepared, because I know the procurement unit would also question it. But according to what I've seen in the records, the next tender was produced in 2013. That's just what I've seen.
If we look at 8.1 through to 8.24, then, Dr. Glasgow, what you say is that tenders were invited in early 2019, and you've exhibited a press release, which, Commissioner, for your note, is at page 359. You say that tender documentation was prepared in draft for intended publication in February. But it was later decided, and we see that from the press notice, that the documents would be available from the 10th to the 22nd of March. But you continue that, having investigated the matter with the procurement unit, there are no records on file that suggest the 2013 tender was ever published. And you say, despite the loss of files in 2017, if the 2013 tender had been published, I would expect to see some record of that on the electronic files. If it was not published, the reasons for that are unclear. Just so that I can just understand that, when you say that it wasn't published, are you referring to the public tender notice or the actual tender documents?
Okay, so what happens is the procurement unit would prepare a tender notice. They would draft a tender notice, and they would forward this to government information systems, who will then publish the tender notice, which includes access to the tender document. So whatever I would have said in 8.4, you would have seen some record noting that it was published. GIS, Government Information System, would copy the procurement unit on whatever was published. Also, I didn't write it here, but just to explain a little bit here, what has been seen on the files, on the electronic files, are preparation of what's noted as a checklist. And in some of my documents, I mentioned a checklist. And that's basically to say, these are the persons submitting the bid. Do they have these particular documents? They just check it off. That would be something that would be stored on file electronically. And so I did not see that. What I saw was a checklist that was blank. It didn't have any persons. So the procurement unit clearly prepared for tenders coming in. They had a draft evaluation criteria. It was put in place. They even went as far as noting the date that the tenders would be in. And again, noting as the checklist, what the checklist information would include. Those files were on the system. However, they were not filled in, which suggests to me that tenders did not come in. And what further suggests that perhaps tenders were not published. So that's why I would have made that statement.
So, similar to 2010, there were steps taken towards the tender process, but for some reason it did not. It failed. It did not. Yes, it was not completed. Yes, thank you.
So if we then turn to the circumstances of 2014, which you covered, Dr. Glasgow, your 9.1 to 9.4. What you identify and that your research has shown is that in April 2014, the Ministry of Education submitted draft tender documents to the procurement unit in relation to the supply of security services to ESHS. You note that the Central Tender Board recommended that a request for proposal be used to initiate the process. Could you just explain what a request for proposal means?
Sure. So typically what would have sent to in 9.1 from the Ministry of Education to the procurement unit as a draft, typically at that time, they would have used a tender document has conditions that's catered to works, so construction works. In terms of the terms and conditions, of course, the scope of the services would have been correct. But when you get into the terms and conditions of the tender document, it was not akin to services. So I can actually speak to this because this is when I came on the scene, when I started to work at the Ministry of Finance. So we know from dealing with projects recently and services, you can't really have the same conditions on a services type contract or services type tender as you would have on a works. So a request for proposal is geared towards a company producing a service. And so the structure of and the dialogue and the language in the tender document had to be changed to what is referred to as a request for proposal. So the proposal, of course, there would be a technical side to it and there would be a financial side. The technical is going to tell me how you plan to deliver the services, and of course the financial bit. So a request for proposal, that form of a tender document, would have been more appropriate to use instead of what would have been provided by the Ministry of Education at that time.
What you also add in your affidavit is that on the 27th of August 2014, the Financial Secretary wrote to the Permanent Secretary at the Ministry of Education reminding the Permanent Secretary that a request for proposal was required before the project could move forward.
Sorry, Commissioner,
Sorry, I'll rephrase that. So April 2014, we've got the submission of draft tender documents to procurement unit. Central Tender Board recommends that a request for proposal be used to initiate that process. If you go to 384 in the bundle.
Page 384.
384, yes.
Okay.
What we see there is, this is the 27th of August 2014. So we have the permanent secretary being written to by the financial secretary in relation to the Supply Security Service. And what it says is, you're reminded that the request for proposal is required before the project can move forward. The Ministry of Finance would appreciate if this information could be forwarded as soon as possible. So that's at least up until August 2014 seems to have held up the process being taken forward. And nothing else seems to happen in 2014 until the 21st of January 2015, which you refer to in your affidavit, and that's when the Central Tender Board chairman sought an update.
Right.
Now you explain, and this is at, so yeah, sorry, if we look at 9.1, you refer to that 27th of August 2014 memorandum that we just looked at. The update is sought from the Central Tender Board chairman, and then at 9.2, you explain that a tender document was drafted in September 2015, covering a 2-year period. And the public tender was issued in November 2014, and there were 2 responsive bids, one from Top Priority and one from Virgin Gorda. And Top Priority was ranked, their bid was ranked more highly than Virgin Gorda's, is that right?
Correct.
And that went through the process, did it not, of a technical subcommittee applying evaluation criteria and a scoring system?
Correct.
And one of the concerns over Virgin Gorda was that they were a relatively new company and might lack the resources and experience to perform the service.
Correct.
And the effect was that the Central Tender Board agreed with the view of the technical subcommittee, and the recommendation that Top Priority be awarded a contract was put into a paper for the purpose of Cabinet's approval. But it seems that, as you say in your affidavit, that no such, it doesn't appear to have gone in front of Cabinet, is that right?
Correct.
Now, if I take you to 9.11, please, Dr. Glasgow. At 9.10, you mentioned that the paper, which was drafted on the 19th of January 2016, doesn't appear to have been advanced to Cabinet. But then at 9.11, which is probably where you become directly involved in the process, you say that a re-evaluation of the bid was requested and undertaken by a new re-evaluation team of which I was a part. And you've made as a team a number of recommendations, which was essentially that you found deficiencies. Tell me if it's not a fair summary, but you found deficiencies in the process, and that the tender document was inadequate and the process had to be terminated.
I wouldn't say it like that. So specifically, we were asked to reevaluate the tenders. I could not remember why. I just remember I'm not sure if it was because if you looked at the prices, the price being the one to be selected, it was on the higher side of, because if you remember, the contract in 2010 was about 455,000. So if you multiply that by 2, we're at about 900,000. And of course, you can see from the monthly payments that were demonstrated in a later table that the payments actually dropped. So you would have been about 900,000, and the bid came in for the very same thing for about 1.2. So naturally, there may have been some concern, I don't know. But we were asked to reevaluate the bid. And so once I got involved here a bit, and the particular team that was put together to evaluate, not that that the tender document was insufficient, I won't say that, but what we realized from the bids coming in, and I alluded to this earlier, is you have one bidder that's saying that I need to have about 6 or 7 persons there. I need to have this in place, that in place to ensure nobody gets over the gate, to man this particular block that remains, etc., etc. And then you have one person, the other bidder says, well, I can take care of this with just 2 persons and I think it was 2 persons had in his 2 guards. Clearly, it may have been that the tender document was not clear enough.
The tender documents, as opposed to the earlier one in 2003, whenever it was, which I think specified the number of people.
That's correct.
This didn't.
This did not. And so as mentioned here in part E of 8.9.11.
If we want to look at your report, it's at 456 in the bundle.
Okay. So what was noted here in the affidavit is, with the benefit of hindsight, of course, you know, not necessarily that this number of security guards would have been put in and say, give me a proposal to have 6 security guards. Government should not take that kind of liability. Generally, what happens in a procurement process is where you have a request for proposal, you would give the requirements. We need the school, and I think I pointed it out here someplace. The specific requirements were to, you know, we need the school to be safe. We need security at the various points. You tell me how you provide that, without me telling you how many persons to use, because you just don't do that. And so what we realized, and it was part of the recommendation in this particular evaluation, is a feasibility study was never undertaken. So we did not know what the ratio of security guards to school students should be. We did not know exactly how many guards you need to be able to get the school properly secured. This was not known. And so this was pointed out in the re-evaluation report as those kind of things. It needs to have some type of feasibility study to tell us this information. So now we can put this information within the scope of the tender document, where all bidders will know exactly what they're responding to.
I mean, if you look at 456 in the bundle, when we go to that, that's the first page of your re-evaluation report. And we can see at 2.1, you appear as part of the team. When you go to 459 and your recommendations, what you say at 4.1 as a team is it's recommended the tender process be terminated as a result of inconsistencies in the bids submitted, which may have been as a result of an inadequate tender document. Sort of
the operative word is may.
May. Yes.
That could have been a reason.
So the proposal inviting bids may have been insufficiently clear to allow the bidders to fully set out what they could provide.
Correct. I would say that, yes.
And therefore, the recommendation of your team was you've just got to stop this process and start again.
Correct.
And one of the one of the conditions you put or proposed was, and in your affidavit you say that your team and I also, or my team and I also took some preparatory steps towards a feasibility study. And this is an abridged, you recommended an abridged feasibility study to, as you've explained, determine the specific requirements in a number of ways, and you've used numbers of guards having regard to size, student size, and the demographics of the school, and the size of the school. That was, you identified that as one of the starting points. Now, the effect of that is firstly that in 2016, there's another attempt to get a tender process off the ground, but those efforts come to nothing.
Great.
The next step for the consequences that Top Priority continue providing services on a rolling basis, month to month, under the existing arrangement. But there is then no tender process or no new tender process, isn't there, until we get into, in fact, until we get sort of much later on in time, into 2020. Is that right?
Well, there was not one in 2020, but the discussion started in 2020.
Yeah. And at any time, I'm taking that from 2016 when your team gets involved to those discussions in 2020, was a feasibility study done at all?
I do not know that there was. I have not seen, and me recollecting, I don't believe one was actually done that was passed on to the Ministry of Finance. The feasibility study would have been completed by the Ministry of Education. I have been included in some ways some assessment to assess them, and also some draft questions that they can use to start the process of the feasibility study. But based on the records and what I've seen, I can't be certain that it was done. Of course, you would have had ARMA happen after that, and in some ways things would have just been lost in the process, and we would have been moving, we would have gone to, as noted later on, to 2 different locations, etc. So I mean, in all fairness to the process, I haven't seen a feasibility study, so to say we know what those requirements were, I'm not sure that they were there. There are minutes, so it's on the record as well, of the procurement coordinator through the Central Tenders Board's meeting, making follow-ups to just to ensure that we're still thinking about tendering for the security, because it remained on the agenda from that time. But like as I mentioned, in 2017. I can't speak to what happened between 2016 and just before the storms, but at that time, a lot of the focus on what we're doing and trying to get back up, I would say that put a dampener on the process going forward, because of course you had the splitting of the 2 schools, and I'm sure that there were talks about let's go through a tender process, but just the mechanics of doing it, and just after ARMA, with so many different focuses, I can't imagine at that time they would have forged forward to necessarily get this together.
But would a fair summary of it be that we can break events up into time periods? So taking 2005 first, so 2005 to 2008, this consideration of the need to tender. 2008 to 2010, you have a tender in place. Then 2010 through to 2016, again, there is consideration and there is of the need to, or the desire or desirability, and in fact the need attempts to put a tender in place, but for different reasons those don't come to fruition.
Correct.
And then, as you say, you know, the storms bring a different dimension to those efforts, and what public officers can do in those circumstances and with the resources they have at those times would obviously be affected. But could I ask you just to look at, I think it's page 185. This kind of, I think, reflects where we've got to now. We're in March 2018, and it's a request from the Permanent Secretary of the Ministry of Education to the Acting Accountant General, requesting special permission to have top priority invoices accepted for payment until information with regards to tendering process is sent from the Ministry of Finance. At this time, the tendering process has ceased. However, the current company, Top Priority, continues to provide security services. Hence our request for special permission to have the company be compensated while the decision has been made to commence the tendering process. And this will continue until the finalisation of such process. So can you just assist the Commissioner with the circumstances in which, why would the Ministry have to go and ask for special permission?
To be very honest, when I saw this, I have never seen a correspondence like this before, and so it appeared and clearly, and as I would have said in the payment section of this affidavit, the Accountant General, the position the Accountant General takes, if you do not have certain things in place, persons will not get paid. It has been the entire Treasury Department. I mean, it can be very, for me as a project officer who assists with payments, you know, you have to have certain things in place to get payment. And of course, rightfully so, because they do have their financial instructions that they follow. And so I can imagine payments would not have been made unless some special arrangement occurred. I'm not sure to what extent the financial secretary at the time was involved, but I'm sure that there may have been some conversation. And of course, the Accountant General would have said, well, I will not make a payment unless I have something on file to say, requesting whatever special permission to allow for the tender process to finish, unless I have something on file to, for lack of better words, to cover myself should this thing come into question. So I can see the Accountant General saying something like that to the Ministry of Education, and also the discussion whether it would have been with the Ministry of Finance, the Financial Secretary, that this is exactly what needed to be done to assist with payments. What was clear is a few things that are clear. One, as we mentioned, no tender process was concluded at this particular time. Payments continue to be made. At some point, you know, the persons would have felt uncomfortable, not with arrangement as was seen in 2020. But what the Accountant General did to assist with this, the provider was providing the services, he had to be paid. And I would say that it's one of the focuses of government, at least the Ministry of Finance. Once somebody performs work for the government of the Virgin Islands, it's good practice to pay them. It's only fair to pay them. So you would hear the Financial Secretary say, if somebody's workers, they have to be paid. And that's not just this financial secretary. I've heard it, at least 2 financial secretaries have been under up since my tenure with the Ministry of Finance. So, but of course, this represents a mechanism that allowed for that to happen. And so that's why, in my opinion, this letter was written. Because I can imagine the Accountant General would say, no, we cannot, we just cannot do this anymore.
Mechanically, the monthly payments have been made over 10 years or many years. And mechanically, how would that have been done? Would that have been done on the basis of purchase orders? What would be sent to the Treasury, to the Accountant General, to trigger the payment?
Okay. So the provider would have submitted an invoice
to the school,
or either to the school or to the Ministry of Education.
Yes.
I think at this point it was being paid on the Ministry of Education. So they would have made
one or the other. Yes.
The Ministry of Education, of course, they would have, and there was a budgeted amount for this. This particular services was budgeted every year.
Yes.
And so they would have made an application, or I said application, but they would have make a requisition for a purchase order. And so that purchase order would have been released if they had sufficient funds. If not, it would have gone on budgetary hold. They would have called the Ministry of Finance budget unit. The budget unit would have released it. So a purchase order would have been done. Now that purchase order triggers the ability to produce a voucher. So the Accountant General needs to see a voucher with the invoices. So that voucher would not be created unless a purchase order.
And purchase order comes from the ministry, from the accounting officer,
correct,
the permanent secretary, and then who produces the voucher?
The permanent secretary.
Okay, I see. So the invoice would come into the permanent secretary. The permanent secretary would produce a purchase order and a voucher, send it off to the Treasury, and the check would be sent.
Payment would, yes.
And that would happen every month.
Yes, it's very thinkable that would have happened.
Yes, no, I see. Thank you very much.
And what you say in your affidavit, Dr. Glasgow, is that there was no tender process in 2020, and that's at 10.1 in your affidavit, page 23. But you then take us back, and this relates to the questions that the Commissioner's just been asking you, but you take us back to paragraphs 4.3, 4.1 through to 4.4 of your affidavit, where you set out how the contracts have been, or the payments have been budgeted for. So in effect, what has been happening since the end of 2010 and the move over to monthly payments to top priority, they have just been paid out of an allocated element of the budget for the Ministry of Education.
Correct.
But this is where it takes us back to 2020, because in March 2020, concerns were raised over, and this was by the Ministry of Finance, over the amounts being charged. Is that right?
Correct. Well, not the amounts being charged, but the ability to make payment based on the amounts being charged.
I see. So if we look at 4.3 and 4.4, please. You say that I've been told by the Financial Secretary that in March 2020, the Ministry of Finance raised concerns about the amounts being charged for the security of students at ESHS.
Yes.
And then the Ministry of Finance had suggested that funding was not available to accommodate purchase orders in respect of payments for the services for months January and February 2020.
Correct.
And the concern was that those payments would exceed the petty contract threshold. Because and you quote then from an email, based on the amounts of the first invoices, the minimum amount to be paid by the end of the year is $600,000.
Correct.
And so the effect is that it was a query about the total amount that would end up being paid for the year based on the first 2 months invoices in 2020,
Correct.
because it would be way in excess of the petty contract threshold.
That's correct.
So there was the money was budgeted, so the money is in the budget. The accounting officer, the permanent secretary, would produce the purchase orders. But given the amount each month, which was whatever it was, $50,000, whatever it was, who would have to sign that off? Just the accounting officer?
Yeah, once there, so the Ministry of Finance would, of course, allocate monthly allotments to the Ministry of Education to make payments.
Yes.
But purchase orders are signed by
The accounting
accounting
officer.
officer. The voucher,
Yes.
as well.
Yes.
It's the
So nobody else would sign those off. The accounting officer would sign those off. They'd go to the treasury.
yes, or they designate, of course.
Yes. And just because the purchase orders obviously reflect the amount in the budget, but don't really reflect a sort of contract, a document. I mean, not a.
Well, what the one of the things I've always said to people, in my discussions, you have several types of contracts.
Yes.
And,
Yes.
the courses that are taught to contractors, government has what we call a major contract. You have a petty contract, and you have, in my opinion, the very basic form of a contract, which is a purchase order.
Yes.
I tell you to do this, you agree to do this for me. So once a purchase order is produced, it's produced in line that a particular vendor has agreed to do it for this. And that agreement, it's by them sending an invoice, it's triggered by that. And so a purchase order is prepared in triplicates. Make sure I get this mechanic right. Triplicates, one copy goes to the vendor. And I believe that's the original, that's the main copy, because it's an agreement between the government and the vendor. This is what we want you to do. By you accepting it, it tells us that you're going to do it. So I call purchase orders contracts.
I absolutely understand that. I agree with that, because there must be a contract to get the works done. But in terms of these services, what could have happened, perhaps what should have happened, is that there would have been a contract for $600,000 or whatever it is for the year, and that would either have gone through the tender process, or it would have been waived, but there would have been a contract, and that at $600,000 would have been approved by cabinet, well, in one form or another, because they could have waived it. So that's that. And who would have signed that contract then? It wouldn't have mattered as long as cabinet had approved it. Who would have signed the contract?
No, the contract itself. I mean, the legislation notes. I think the Minister of Finance signs contracts, or if he designates.
Right. Okay. So what all contracts under the regulation. So he probably would sign.
He would sign
the contract.
I know there's some years, of course, and he would actually do an instrument and assigns perhaps other ministers or accountant officers to sign contracts.
I understand that. So that's fine if there is a document headed contract, and that's that. But in terms of what was happening here, there was no such document.
Correct.
It was a sort of rolling payment, and there were purchase orders. But what sort of was behind the purchase orders? The purchase order for $50,000 signed by the accounting officer, and so there is something missing, isn't there? There's a contract missing. So far as the audited, the Treasury is concerned.
Yes, Treasury would have picked up, and Treasury would have picked up that
exactly at some point. Yes,
and it would not have been a secret that this was ongoing, and tender processes were started, just never completed.
Yes.
So we know that there's not a contract, and so what we picked up in 2020 and the Ministry of Finance identifying it, at least they have identified and decided to really make sure that something happens. And what you can see from the chain of emails is it was identified, of course, because of the natural mechanism. If you try to enter a purchase order and you don't have the allocation, the system will put it on hold. And so the system put it on hold, which therefore made it necessary for the accounts officer to call to the Ministry of Finance or the budget unit to release the purchase order. So that's where the emails pick up. And so
No,
Ministry of Finance said, no, we can't do that because it will be a major contract. Let's get an approval from Cabinet.
Yes, yes, thank you very much.
We can see the emails. They started.
Now, Mr. Rose, I know the
Of
time,
course,
because
yes.
the
I'm
start
sorry,
has been
Mr.
going for
Castor.
a long while. How close there are you to finishing? We're up to 2020, but
A little bit more. So I think we should give Mr. Casdan
Yes.
and everyone a break.
Dr. Glasgow, we have a stenographer, and he just needs a break every now and then. We've been going quite a long time for him, so we'll just have a 5-minute break, and then we'll come back and finish your evidence. Thank you very much. Good. I think we're ready to proceed, Mr. Rowett. Thank you.
Thank you, Commissioner. Dr. Glasgow, we're jumping between paragraphs 10.3 and 4.3 of your affidavit, but essentially, if I go back to 10.3, and this picks up the point you were discussing before we had the short break, they reached a point in 2020 where and this is in March 2020, essentially the Ministry of Finance were raising queries over the payments being made, because if it boils down to that purchase orders were being made to pay what appeared to be a major contract.
Correct.
And again, Minister, for your Commissioner, for your note, you have the chain of emails that Dr. Glasgow refers at his 10.3 at pages 189 to 193. I don't need to you to turn it up, but in 189, the permanent secretary in the Ministry of Education in the Ministry of Finance writes of the situation that it's regrettably one of the matters that I've inherited, and I must say it should not have been allowed to continue in this manner over the several years that it has been going on. It's my understanding that years ago a tender document was issued for security services, but the matter was not finalised, and this is the process that the Ministry has been following. Why it was not flagged before, I'm not sure, but I do agree it cannot continue indefinitely, as it is a violation of the Public Finance Management Act. And I assume, Dr. Glasgow, that's something that you would agree with, that firstly, it couldn't be allowed to continue indefinitely. Correct. And that it was, what had been allowed to continue was in violation of the, you've been calling the procurement regulations.
I would say so, yes.
If we focus on 10.7 of your affidavit, please. What you've done, and this is very helpful, but at 10.6, you set out some more details of some of the correspondence that was ongoing, because I think there were sort of two parallel processes going on, dealing with the instant situation that had been flagged up by the Ministry of Finance, and then beginning the step of perhaps remedying the situation by having a tender process in place. So we have at 10.7 reference to a Cabinet Memo of the 7th of July 2020, which if we turn that up is at page 441 in the bundle. It's a Ministry of Finance memoranda dated the 7th of July 2020, but gives us helpful background, which we've already covered. First, it makes reference in paragraph 1 to the tender process that was completed in 2008 and led to an award of the contract. It then refers to events in 2015 when there was a attempt to again go through a tender process, but which did not go as far as Cabinet for reasons you've explained, and the fact that monthly payments have then continued. Point at paragraph 4 is that Mr. Letson Smith, who does business as Top Priority Services, had not actually increased his rate over the years. But what had happened was that in September 2019, there had been a separation of the junior and senior sections of the school. And so that led to an increase in the number of security officers in any event. And the purpose of this paper was for Cabinet to ratify a contract between top priority security services and the government of the Virgin Islands to provide security services for Elmore Stour. Now, as I understand the purpose of this, it was essentially to, because of the need to have security at the school, because top priority had been providing its services in 2020 but hadn't been paid, and was in effect, the circumstances pointed to a major contract. What Cabinet needed to do was to waive the tender requirements and ratify a major contract in 2020.
That's correct. You rightfully noted that, and from the email chain, payments were not made after February. I think February was the time. So to complete the payments, as the budget unit flagged, they needed a cabinet decision. And so all papers for waivers are done by the Ministry of Finance. Well, the Minister of Finance carries papers for waivers to cabinet. And so there you have the Ministry of Finance preparing that paper. So one, of course, as you mentioned, give the ability for the vendor to be paid, and two, allowing time for a tender process to be done, which you would note that the cabinet decision, or the request and the cabinet decision, noted payments throughout the entire year of 2020.
And I think, to be fair to top priority services, security services, they had done two things. Firstly, they had continued to provide the service even though they hadn't been paid. And then secondly, because there was a move because of the pandemic to online education, they had also reduced the numbers of officers that they were providing on site. But nonetheless, and it goes back to your point about the Financial Secretary saying government must pay its bills, a bill had been incurred and that had to be paid.
And rightfully so, the bill, I would say, if you were to ask me, you didn't really ask, but if you were to ask me, the bill was a necessary bill. And I'd say that because security of the schools had to be done, and especially during this time.
Yes.
It's something that had to be done. And so I think that was a major part of the cabinet paper to justify why we should do what we're doing.
And just one, Mr. Rowett, is there a cabinet decision in here?
Yes.
We probably don't need to go to it.
If you give me a moment, I will find it. I had it in my notes, but I now, of course, can't find that in my notes. But I'll check that.
Yes, it's here somewhere. Anyway.
Yes.
Yes. Thank you.
So what we see, the evolution in terms of events in 2020, Dr. Glasgow, is there's the intervention of the Ministry of Finance brings to an end the month-to-month payment process. And as we've seen, two things are happening. Firstly, that Cabinet approves that major contract between top priority and the government. And as you've said, it was justified on the basis of the need for a continued security presence. There was the recognition that under the public finance management regulations, Cabinet can waive a tender process. There was the recognition that a service had been provided and costs had been incurred. And also that the Ministry of Education had accepted that moving forward, it would need to comply with the tender process and the public management regulations when seeking security contracts for secondary schools.
Correct.
And as we've said, and as you say at your 10.5, parallel to this, a tender process was initiated in 2020. But that, as I understand it from your affidavit, could not be completed as a process before 2021.
Based on what transpired, it did not initiate, but it was not published until 2021. But in fact, what the idea was is for that tender process to be completed before 2021 to allow now payment after December 31st, 2020. Because Cabinet's ratification of the contract is for payments to be made through December 31st. So the idea was to have a tender process to effect payments that will begin on January 1st, 2021. So if you would,
but in your paragraph 17.3.
17.3.
Yeah. What you seem to say there, which makes sense, that there is a contract up until the end of, or there was a contract up until the end of June 2021 to allow the tender process to run its course.
Yes, so this was before this. It's a very good point that you make, because this now picks it up at January 1st.
Yes, 2021, yeah.
But the cabinet decision, the cabinet paper, I'm trying to find the decision myself here. It was to ratify that contract to the end of December 2020.
Right.
2020. So that would have allowed that parallel process of the tender process being done to be completed. So you can have somebody in place by January 1st. So now payment can be made in accordance with the procurement regulations. But of course, that did not happen. Hence now where Commissioner, your 17.3 note comes into place.
So that sort of fills in.
So we need another contract at January to get us to June.
Yes, and that, I mean, more or less allows the successful tenderer to take up the contract from more or less the beginning of the school year.
Correct.
That sort of time. Yes, got it. Thank you very much.
Could you just clarify for me then, Dr. Glasgow, if you look at page 730.
730.
So the contract, the cabinet memo that we were looking at earlier puts in place a major contract to cover till the end of December 2020.
Correct.
And if we look at 730, that is an expedited extract dated the 7th of April 2021, and sets out Cabinet's decision to ratify a new major contract for an additional period of 6 months. Or until the completion of the tender process, whichever comes first. So, was that decision to have, so that it would ratify a contract which would cover the period 1st of January 2021 to the end of June.
Correct. So that's what we just discussed on 17.3.
Right. Yeah. Okay. And in terms of the tendering process, if we look at 705, please. That sort of sets out the firstly under background information. It sort of serves as a way of, I think, bringing us up to date as to where we are now. So where we've reached in effect is that after 2010 and the end of that completed tender, there is no there's no successful tender process as yet, but there is one that began in 2020 and will be concluded in 2021. So that helps us again because it does explain as a document the fact that government has extended for a period of 1 year to December 31st, 2020, the contract of top priority. And then it explains just the details of the tender process that you've engaged in. So tender documents were available from Monday, the 25th of January, 2021, with a submission date of the 23rd of March, 2021. There was a pre-tender meeting on the 16th of February, 2021. 7 bids were received from a variety of security companies, and they were opened during a central tenders board meeting held on the 23rd of March, 2021. And I don't need to go into the detail of this, Dr. Glasgow, but 2 questions really. Firstly, have those bids, or are those bids then going through the process that you summarised earlier for us, which was to the Central Tenders Board, possibly allocated to an evaluations subcommittee. Once they've gone through that, they will then go to Cabinet with a recommendation, and Cabinet can accept or reject the recommendation.
That's correct.
So as a process, and maybe a process that you're directly involved in, but as a process and as part of the work that you've done for your affidavit, are you satisfied that at least that process from 2020 to now is in compliance with the regulations?
Yes.
And in terms of I mean, it's a salutary tale, I suppose, of perhaps the positives of the tender process, but also the difficulties that might be associated with the tender process. But do you think that as a result of the work you've done and the people you've spoken to, have there any lessons been learned about how ministries can respond better to the need to engage with the procurement regulations?
Yes, I think this is definitely one of the lessons book, and quite a bit of lessons to be learned here. One of the very first thing that I speak to my team about is the need to ensure that tender document, or whichever form you choose to use, whether a request for proposal or tender document, it has to be specific enough and it has to be concise enough to allow all bidders to fairly respond to that tender in a way that it's understood. One of the shortfalls of not doing an appropriate tender is exactly what happened in 2015, where you have bidders submitting bids, and when you go through the bids, it's not clear that they received the same information or they interpreted the correct way. So one lesson learned, of course, is to ensure that your tender document is structured in a way and prepared in a way that everyone understands the requirements, and it has to be the same requirements. Another very important lesson, and I think is as a success story for all of this, is the fact that we have mechanisms in place to trigger when something is not correct. So the chain of email that we went through between the budget unit and the permanent secretary, it shows, of course, that there was a flag. As the permanent secretary rightfully mentioned, she's not sure why that was not flagged before. I can't say, I don't know, I haven't seen the records. But I'm sure somebody probably asked the question already. But clearly you have an automatic system that flags it, because the accounting officer or the accounts officer trying to raise a purchase order against a particular vote it was placed on hold. One, because the budget allocations were not there. And then two, with that placed on hold, I mean, the way how I remember how the system works, a big B will be noted at that particular line item on the system. And of course, now the budget unit picks up on that and see that, well, there's an issue. There may be an issue, and they go through and they would see, of course, that if we were to continue this, we would have a problem at the end of the year because we would be in contravention of the regulations. And so it's one of those fail-safe methods, and it's definitely a lesson learned for us. And as I mentioned, a success story, because there are triggers, there are certain things in place that triggers if something goes wrong like this.
That's true, in that somebody eventually put a flag up and payments were stopped, and the mechanism began to sort all of this out and to put it on a proper procurement basis. But when you say there was an automatic trigger, it took, there was a period of what, 10, 15 years when it was not triggered. Well, no, sorry, that's not fair, because every now and then there was an attempt at a tender process, which for one reason or another did not come to fruition. But it took a while for this to be sorted out. I can put it that broadly.
Yeah, that's correct to say. And where the automatic trigger, as I called it, came into play was, again, of course, an accounts officer trying to raise a purchase order. And this is just on the system, enter purchase order. Oh my goodness, I do not have any money because a budgetary hold goes. So of course, they now have to go to the budget unit to ask for permission to release the hold. So that's the trigger. I mean, maybe that had not happened before, because they would have already have the monthly allocations that were allocated in the budgetary. But because that particular month represent, and it's not that they didn't have the money, it's just that it wasn't allocated in that month. And so by that not happening, it triggered that. So
yes, thank you.
And I mean, to sort of pick up on the Commissioner's point, I mean, if we take the end of 2010, and this is if we look at your paragraph 15, the table that's at paragraph 15 on page 27. Once 2010 starts, and through the next 10 years to, let's say, the beginning of 2020, the payment that is being made by the Ministry of Education is on purchase orders. And if we look between January 2011 and December 2012, $714,447 are paid out. Between January 2014 and December 2019, $2,995,100.45 is paid out. After January 2020, and so I mean, those are substantial sums paid out on purchase orders, aren't they,
yeah,
Dr. Glasgow?
on individual purchase orders, yes.
Yes, and they are sums that really are well in the realm of the major contract.
Well, I don't believe, of course, the record doesn't show this for me, but of course, this would have been cumulatively, yes, it would have been well over a major contract, the threshold. I mean, but the individual purchase orders, remember the payments were done monthly.
Yes.
So they would have been like.
I accept that, absolutely. But that across a year,
yes,
you are in, I mean, we can look at, if you look at page 153 in the bundle, I won't read these figures into the record unless you require me to do so, Commissioner, but what these are payment schedules. And so they show what was paid. If we go from 153 onwards each year, starting with 2013 through to 2014, 2015. We've got 2016, 2017, and 2018, and then you have 2019 through to 2020. Now, 2013 through to 2016 is over $300,000 paid out each year. When we get into 2017, it's closer to $500,000. The same in 2018, the same in 2019, it's actually over $500,000.
It's on 152 then.
Yeah. I mean, I leave out 2020 because that would, of course, be when the contract was in place. But it is a significant time over which there was a failure, and I appreciate you won't know all the reasons for it or the circumstances in which it occurred, because despite all your hard efforts, there are some documents missing. But it is a serious failure not to have complied with the procurement regulations over a significant period of time. Would you agree with that?
Yeah, I would agree, yes.
And obviously, as you've explained, steps have now been taken since the beginning of 2020 to remedy it. Firstly, by using the tender waiver process to put in place major contracts, and then to have a tender process, which is at some point this year will be concluded. Correct.
But I would interject that steps were, as we've discussed, steps were taken back in 2013 to effect the same.
No, it's quite clear that in the period that I have identified, as your work has shown, is that it must have at least been in the contemplation of public officers that there was a need for a tender process.
Yes.
Commissioner, I've reached the end of my questions.
Yes.
Can I conclude by thanking Dr. Glasgow, not only for the work that's gone into this affidavit and the care that's been taken in collating the documents as well, but also for coming to give evidence today and the way he has assisted the Commission.
No, and can I thank you also, Dr. Glasgow, for the clear and helpful way you've given your evidence. It's been very helpful to try and to explain what has gone on with these particular services over the last 10 or 15 years. Thank you. Good. Mr. Rao.
Dr. Glasgow is our only witness today, but we will be resuming on Monday with further witnesses.
Good. Thank you very much. Thank you again, Dr. Glasgow.
Thank you.